Hello, hope you are doing well. I, Shashank Mishra, as a host in the Law and Life, to present here with Senior Advocate of Supreme Court of India, Subodh Markandeji. This channel is an initiative by Senior Advocate to share years of experience and discusses on various legal issues. In this episode, he will talk about the Limitation Act 1963 does not apply to carriage by Act 1972. On this, my first question is can you conceive of any civil cases in which Limitation Act does not apply?
Yeah, I when this question cropped up about the topic of today's discussion, I just looked up and I came across a judgment delivered just on 29th of July 2022, that is just 3 days back. So this is a judgment right pat on the point of what we are discussing today. So in Bhagwan Das Ramchandani versus British Airways, civil appeal number 4978 of 2022, a bench of Justice Joseph and Justice uh, P.S. Narasimha, judgment has been delivered by Justice Narasimha. The Supreme Court has held that uh, the Limitation Act 1963 does not apply to the proceedings under Carriage by Air Act 1972. So that is what we are going to discuss today. So here, Supreme Court has held that applicability of Limitation Act uh, does not apply to the suit filed by the appellant because the right itself has been extinguished. And the second thing which they have held is that uh, the uh, Carriage by Air Act excludes the provisions of Limitation Act.
So please tell us more about this case.
So here, very briefly, what has happened is that the appellant, Bhagwan Das B. Ramchandani,
Yes, sir.
he sent two consignments of fruits and vegetables from Mumbai to Canada via London and availed the services of the British Airways, that is the respondent in this particular case. So, uh, for all the reasons which can't be attributed to either of the parties, the consignments could not reach the destination and perished at London. So the appellant, issued notice claiming 5 lakhs odd rupees as compensation. The British Airways wrote back saying that they are prepared to settle the whole issue at half the value of the claim. That is, let us say, 2,50,000 odd or whatever. But instead, the appellant filed a suit in the City Civil Court in Mumbai, and the trial court held that Limitation Act applies and accordingly decreed the suit. The respondent British Airways carried a writ petition. They filed a writ petition in the Bombay High Court, and Bombay High Court allowed that writ petition, uh, and relying on a very large number of judgments, Indian and foreign, including the judgments of the Supreme Court of India, it held that Limitation Act does not apply because the provisions of Carriage by Airways Act excludes the uh, applicability of the limitation. So naturally, the appellant carried uh, an appeal by special leave to the Supreme Court. This is the appeal, that is civil appeal number 4978 of 2022. So all I can say is, uh, having regard to the constraints of our format, I can't discuss threadbare, although I would like to discuss this particular case threadbare at some occasion, because it was a delight to read the judgment. It considered, all the provisions of the Carriage by Air Act 1972, the provisions of the Limitation Act 1963, all the foreign judgments which were cited, all the Indian judgments, including the Supreme Court judgments, and then held that uh, there are two questions actually court framed for its consideration. One was whether the Limitation Act, extinguishes
Yes,
the
sir.
the right itself. When the right itself is extinguished, there is no question of availing any remedy by way of suit or otherwise. Secondly, whether Carriage by Act, excludes expressly the Limitation Act. And after considering all the material before it, including the provisions of the Carriage by Air Act 1972, provisions of the Limitation Act 1963, and all the judgments which were cited from both sides, the court came to the conclusion that the provisions of the uh, carried by Air Act 1972, they extinguished the right itself, because it's an act, of Parliament which has been enacted to give effect to the conventions bearing on the carried by air. So the schedules of those conventions are put in the act itself, and they govern the. So they have to be read together and in a harmonious way. So, so construing, the court said that right itself is extinguished by the uh, carriage carriage by air act 1972. The court also came to the conclusion that uh, the carriage by air act, excludes the provisions of limitation act. It's a conclusion which the court came to after discussing all the provisions of the limitation act itself. Particularly, uh, you will see that the provisions were of limitation act were discussed, and that is particularly section 3 and section 18. Construing all these provisions in the light of the decided cases, the court came to the conclusion that answer to both the questions is against the uh, consigner, that is appellant, Messrs. Bhagwan Das Ramchandani, and upheld the judgment and order of the High Court in writ petition. It's a uh, it's a judgment which needs to be threadbare discussed. It was a delight to read this judgment, but as lawyers, as practitioners, we are bound to examine even the apex court's judgments and derive our own conclusion. Yes.
Yes, sir. This makes me to ask the next question. When is right to sue itself extinguishes?
Will you repeat the question?
Sir, when is the right to sue itself is extinguishes?
Yes, right to sue itself has been extinguished by reason of the those conventions, Geneva Convention, Ottawa Convention, and so on, which have been put in the that carried by air act itself, and they form law. So the international conventions and the our law, they have to be harmoniously construed. So on that construction, the court came to the conclusion that the right itself has been extinguished. And the remedy has also been, in a way, that is to say, the Limitation Act has been excluded from consideration.
Okay.
That's why the suit filed by the uh, appellant was dismissed. I think,
Okay.
I did not say, but I think he should have gone before consumer fora. Probably, I can't say, but the result could have been different.
Yes, sir. Yes, sir. It can be possibility. Sir, that's all. And from here, we will be winding up for the today. Thank you, sir, for joining and saying all about it, sir.
Thank you.